Mr. Backrack? Of course.
Good morning, Your Honors. My name is Barry Backrack, and I represent Edward O'Rourke in this matter. This is on further appellate review from a decision by the appeals court which reversed a decision of summary judgment in favor of Edward O'Rourke. In doing so, however, it never got to the summary judgment issue, and that raises one key issue as to before this court, whether the appeals court was correct in ruling that Edward O'Rourke had prematurely brought a summary judgment motion before the trial court. We submit that the appeals court erred. The appeals court ruled that before a summary judgment can be brought in a probate matter, a party must challenge and object to the affidavits of objections which are filed pursuant to Rule 16. And the appeals court, in so ruling, applied the standards of Baxter and Brogan as to whether the affidavits of objections were sufficient and should have been struck. The appeals court never got to the issue of whether the trial court properly granted summary judgment in favor of Edward O'Rourke.
So is it your view that the affidavits, which were ultimately struck, simply should have been considered as affidavits in connection with the summary judgment motion?
Well, that's in fact what happened, Your Honor. At the summary judgment stage, the trial court considered the affidavits submitted by Edward O'Rourke on his behalf, considered the affidavits of the proponents, as well as the additional evidence that they put in connection with the summary judgment motion, namely medical records.
Why did the court, I was quite curious, why did the court then dismiss the affidavits?
As I view it, what he had to do is he granted summary judgment in favor of Edward O'Rourke, and in order for the probate to go forward, he struck the objections.
Did he have to do that?
I believe he has to dismiss the objections so that the probate can go forward.
Dismiss the objections?
Yes.
Well, what is wrong with that?
Well, what the trial judge was just fine, from your point of view.
From my point of view, that was exactly what he should have done.
And what you are asking, as I understand it, what you are asking us to do is, one, to say the appeals court was incorrect in its ruling, and that you have to go through Rule 16 proceeding before you can get to summary judgment, and two, if we reach that conclusion, affirm the grant of summary judgment to your client.
Correct, Your Honor.
Okay.
And the rule staring in the face of the appeals court is probate Rule 27B, which incorporates Rule 56 and indicates that you can bring a summary judgment at any time. Now, my brother argues in his brief that, again, we brought it prematurely before they could do discovery, but under Rule 56, if the non-moving party felt that further discovery was necessary, they could have filed a Rule 56 affidavit and asked for specific discovery, but they didn't. Rather, the parties engaged each other on the summary judgment forum.
But what's the purpose of Rule 16 then?
Rule 16 provides, the purpose of Rule 16 is to make sure that if a party's objecting, it sets out they have to set forth specified facts that basically pass a motion to dismiss to show there's a justiciable cause. And the appeals court, when it looked at these, stated in its own that these affidavits were not a model of clarity, but they at least met that standard.
Rule 16 standard.
The Rule 16 standard, which is as I read Baxter and Brogan, the Rule 16 standard is more akin to whether you state a claim, whereas a summary judgment standard is more exacting. It's whether or not there's any material disputes of fact.
So you would agree that Rule 16 has a place, procedural place, in this sort of dispute?
It does. We could have moved to dismiss the objections, but we chose not to.
Or strike them?
Strike
is
the
magic word.
objections.
Shouldn't you have done that?
No,
because they would be measured then under a dismissal standard.
And you would have lost.
And you would have lost.
And
then it could have burgeoned into depositions and discovery, which these people may be entitled to.
But I think that's I've got two responses. I think, Your Honor, that's a tactical decision, just as many times one would receive a complaint in a non-probate case where I may decide that I have a chance of moving to dismiss this, but it probably states a claim, but I know on the undisputed facts I stand a better chance of winning. And I would
put it this way: you might find some. I mean, if this happens to be two siblings, I mean, these are the children. So
correct.
You might have some, I don't know, unrelated by blood person who comes in and says, you know, the testator promised me. That's the classic. I was helping him or her in her dying days, and she promised me that I would get the house. If you don't have anything else other than that, chances are you're not going to get past to Rule 16, correct?
Correct.
So that, I mean, it's not quite standing, but it's a very, very low threshold. But there was nothing, as I understand it, that precluded the defendants here from engaging in discovery.
There was nothing, Your
In other words,
Honor.
you don't have to be sanctioned. You don't have to look at it the other way. You do not have to have survived a Rule 16 motion to strike in order to engage in discovery, correct?
Correct, Your Honor.
Am I correct about that?
You're absolutely correct.
So that if they had filed the affidavits and immediately noticed the deposition of your client, they could have taken the deposition, correct?
Yes, Your Honor.
What rule says that?
That they could proceed and take depositions? I think just the general rules of civil procedure incorporated
well, that's true, but, well, all right.
But I take it that if you think they don't have standing, right? In other words, Rule 16 is filed. Before you're not even thinking summary judgment, right?
Right.
Rule 16 is filed. You simultaneously get a notice of deposition. You don't think they're going to make the Rule 16 cut. So you immediately file a motion to stay the deposition and a motion to strike the Rule 16, correct?
Correct, Your Honor.
If you don't think that you're going to be able, if you think that a Rule 16 is, you know, a relative waste of resources, you're going to go ahead with the deposition.
Correct, Your Honor. And in fact, there was discovery here. We jointly got the medical records. Both parties jointly got medical records. There was nothing, as I say, precluding them from engaging in discovery. And
you had who put in the affidavit was that an affidavit of the nurse? I mean, not of the nurse, of the
attorney?
Of the attorney.
We submitted the affidavit of the attorney in support of the motion for summary judgment.
And I take it if they had wanted to, they could have deposed her.
They certainly could have, in response to the motion, and we would have held off the motion if they wanted to take her deposition, because her deposition is really the key here.
Absolutely.
I haven't studied this in the detail you have, but does the Rule 56 part of this exist in rules separate from the probate Rule 16 rules?
Well, yes, because Rule 27 of the probate rules incorporates Rule 56 and Rule 56F.
All right, so this is not a situation where we can say Rule 16 is somewhat part of what has always traditionally been the probate part of the probate court, which is much different than the civil jurisdiction part of the probate court. You're aware of that distinction?
Well, yes, I'm aware, but I'm also aware that probate rules specifically incorporate the summary judgment rules.
Okay.
And Rule 56F states when affidavits are unavailable.
Yeah, I know that.
Okay, and that was my point, Your Honor. They had remedies if they wanted to take depositions or discovery. They could have. Frankly, if I file a motion for summary judgment and the other party tells me I'm not ready, I want to take that person's deposition, I would rather do that because.
Is there anything in the rules or the case law that suggests that the case cannot proceed until a decision is made on the Rule 16 papers?
No, Your Honor. In fact,
I thought there were some appeals court decisions. I thought not from this court, but I thought there was some appeals.
Brogan.
No, Baxter and Brogan, as I read, simply analyzed the standards of whether the Rule 16 affidavits in those cases were sufficient. I did not read either Baxter or Brogan to say you have to move to strike the affidavits before you can proceed with the case. And in fact, Rule 16 on its face.
It doesn't require the parties to do it, but a judge can do it sua sponte.
Correct. And Rule 16 on its face talks about says may. If an affidavit of objection fails to comply, a party filing such affidavit may be struck on motion with notice. It's may. It's an alternative I could have followed, but chose not to.
I'm looking at Judge Cass's decision, and I mean, essentially what he says is you've got the complaint, then you've got this Rule 16, which is a kind of slightly higher threshold to screen out frivolous will contests. I think that nobody could say just on the face of the affidavit from these children that they were frivolous. In other words, the notion that one child who might have had access had exercised undue influence over a frail elderly woman is not frivolous on its face, right? So you're confronted with that. You say, this is not frivolous. The way I'm going to rebut this is to go into summary judgment. I'm going to get the medical records, and I'm going to get the appropriate affidavit, very, very careful affidavit from the lawyer.
The attorney, yes.
And if the other side had wanted discovery, wouldn't have mattered. I mean, in other words, you can go back through the Rule 16 procedure, and then you're back to where you were in any event, correct?
Correct, Your Honor.
But wouldn't a practitioner have to file papers, under Rule 16? Because if they don't do it within 30 days, a judge could simply strike the appearance and the case would go to judgment.
The objecting party certainly has to file an affidavit to establish that they have a justiciable case, and they have to set forth specified facts. But that doesn't mean that I, as the defending party in that case to the objections, has to move to strike the affidavits. For example, in this case, if I look at...
But if a lawyer didn't file that and was going through discovery hoping to win at summary judgment, a judge could say, I'm not going to even decide summary judgment because you did not file an affidavit under Rule 16 within 30 days, and I'm going to strike your appearance. A judge could do that.
You could do that.
Okay, if an objecting party didn't, correct, the objection could be struck, but I'm not in that position.
Yeah.
So they're required to do that. But my point is that I was not then required to move to strike the affidavit. Yeah. I proceeded with the case, and as Chief Justice Marshall's properly said, and I'll admit, on their face, without the key background information, there's certainly surmise and conjecture enough that would get past the Rule 16 standards. So,
does our case law or does the rule suggest that, okay, there's been discovery, there's a motion, there's the Rule 16 papers, and then there's the Rule 56 or Rule 27, probate Rule 27, motion for summary judgment. Can the judge say, look, I think I'm going to go directly to summary judgment. I'm not going to decide the Rule 16 issue.
Yes, I believe that. I
assume that if you said, well, wait a minute, if you had an inkling which way the judge was going to go, you might say, well, Your Honor, I need to take some more discovery, whatever it was, correct?
Right. I mean, if I were them Monday morning quarterbacking, now they say they needed more discovery, they could have done it, but they didn't. And I brought forth affidavits, particularly a detailed affidavit of the attorney who,
But when this case was presented to the judge with complete papers under Rule 16 and complete papers under summary judgment.
no, it was presented to the judge on a summary judgment motion. They
Can I
filed,
ask you this, Mr. Beckler, because I was just looking at the judge's memorandum. You filed a motion for summary judgment, an affidavit, and supporting affidavits, and then the objectors filed a memorandum in opposition to the motion for summary judgment. In that opposition to the motion for summary judgment, did they say the motion for summary judgment is not ripe because we haven't yet gone through a motion to strike Rule 16?
no.
So this was sua sponte, the appeals court.
I think the first time that issue was raised was in the first appellate brief.
Their brief.
Yes.
So if we look at, because here's, once again, I've got a good probate judge, and unless there's something that says he has to do it sua sponte, the objectors, the defendants in this case, never said, look, you haven't filed a motion to strike.
No, that was never, this case was joined on summary judgment by both parties.
Okay. Thank you, Mr. Beckler. Mr. Kraft?
Your Honor, Attorney Michael Traft on behalf of Maureen Hunter. First, with respect to the procedural issue.
Is it waived?
No.
Why not?
Did both parties proceed as if this was summary judgment in the probate court?
At the point that the summary judgment motion was presented, they proceeded on summary
So
judgment.
your side didn't come in and say, you got to go through Rule 16 first, did they?
I don't believe specifically they said that in that court.
Well, that issue is gone.
And unless there's some reason why sua sponte, a judge has got to say, no, I can't do this, right? And I don't see anywhere that we've said to a judge, you must, no matter what, you must, correct? Because if you think of it in this way, Mr. Trapp, in this particular case, many other cases are different. If you accept my proposition, which I think is a reasonable one, that on its face, the allegations that your clients made were going to get over the Rule 16 bar, why would a judge in a busy probate court say, what you've got to do is go back, file a motion to strike, which, by the way, I'm going to deny?
Well, there are a couple of other aspects of Rule 16, I think, that really were missed in the rush to summary judgments in this case.
Well, but wait a minute. You just told me that your people didn't raise Rule 16 at all in front of the probate judge. So isn't that out of the case? Don't we look at this whole thing now as, is this appropriate for summary judgment or not?
Well, is it appropriate for summary judgment at this point in this litigation in the probate court?
That's the issue.
That's the issue. That's
right.
fine.
So we don't even have to talk about Rule 16.
Except to say that you don't have to do it.
Well, except, yes, I guess.
I mean, you've got an appeals court decision out there that says you can't get to summary judgment. Isn't that the case? They didn't reach the summary judgment.
It's unpublished. It's not out there, so we don't have to worry about it. I mean, I'm trying to get this analytically down to the bottom line.
Yes.
Without a lot of fuss, muss, and bother.
Yes. All right. This is what happened procedurally. The first step is that affidavits have to be filed, which were filed by the objectors on July 29th of 2002, okay, or 2000.
But is a decision on Rule 16 a jurisdictional predicate to anything else happening in the case?
Not argued.
Can't be.
It isn't necessarily. A decision on Rule 16, not necessarily, because it could be waived by the proponents of the will. An objection to the objectors on Rule 16.
Which is exactly what happened here.
Could be.
They made no effort to strike the objectors' affidavits under Rule 16.
Yes.
They moved straight to summary judgment. Now, could we turn to the merits of the summary judgment motion? As I understand it, by the time we get to the summary judgment record, we have the affidavit, the detailed affidavit of the attorney who met with this woman, went over various drafts, what she wanted, et cetera, et cetera. So that's specific. And we have a more complete set of medical records, which seems to put in a very different context this notion that she was, delusional or whatnot, that references a different and earlier period of time, and that the medical records for the relevant period of time and the attorney's observations during the relevant period of time indicate that everything's fine. Why doesn't that allow the judge to say, for the relevant period of time, there really is no dispute of material fact?
Well, I disagree with the characterization of the medical records, and there also are other affidavits here that specifically refute the attorney's representations of her mental state during the relevant period of time. And that's the affidavit of the daughter who went in to see her on a regular basis at that time and said specifically that she continued to be delusional and have periods of delusion during that period of time. There's one other aspect here that relates to the whole problem, and that relates to the procedural issue, which was what I was trying to get to. And that is this, that on October 7th, the parties moved to obtain the medical records. So as of October, in this case, there had been no medical records that had ever been obtained. You can't do any discovery. How can you do some discovery of any of the particular people that are involved, the medical witnesses as well as the attorney, without having the medical records?
Well,
now, there's nothing in the...
Whose fault was that? Whose fault was it that the medical records weren't obtained until October?
I don't think it was anyone's fault.
When did you file suit? Or when were the objections filed? In July?
The objections were filed in July, and the parties filed a joint motion to obtain the medical records. I'm not sure, I mean, it's not clear in the record the reason why there was a problem in getting the medical records from July to October.
You've got the records now. Now what? Why didn't you move for more discovery? Why didn't you notice depositions? Why didn't you do stuff?
Well, I believe that there were notices of depositions that were out there that were delayed because they were waiting for the medical records, and then there was a summary judgment motion filed.
Okay, and did you make a Rule 56F, which is a standard form of opposing a summary judgment, put the summary judgment motion on hold, Your Honor, until I complete the following discovery? You didn't do that, I gather.
That wasn't done below, unfortunately, specifically. I think what the attorney was thinking in doing that was that there was sufficient evidence. Let me get to the specifics now of the issues here. That there was sufficient evidence to refute summary judgment on the evidence that was presented. Now remember, the evidence in support of the motion for summary judgment contained no medical evidence whatsoever. They did not contain any medical records. They provided essentially the affidavit of the attorney, who described the conversations with the woman in the presentation of the affidavit of the will.
Well, that's okay. I mean, what's wrong with that? You certainly want that.
Well, certainly that's fine. But I think in response, you have an affidavit by a daughter who saw her during that same period of time who said she was delusional.
Well, that may create a triable issue.
Yes, that's the point. That is what summary judgment's all about.
I got your point.
Right.
Right.
And beyond that, you have the medical records. Now, we've had a characterization of what the medical records are, but we have no doctor, we have no nurse, we have no medical person whatsoever who's presented anything.
True, but I gather that the witnesses to the will were medical personnel.
We don't know. No, we don't know. That's the point. There's been a representation here, and it's in the affidavit, I believe, of the attorney, that one of these people was there were people who were employees of the nursing home, and then one of these people was a nurse practitioner. But that's all we know about them. We don't know if they were just there that day, whether they've been treating her every day, whether they know anything about her medical condition.
But, Mr. Saffney, I'm going to ask you two sets of questions. I have to go back to Rule 16, because although it's an unpublished decision, it will be read, no doubt, by other probate judges. And what the appeals court has said to this judge, there was an error, quote, committed by the judge, and then cites to the Blogan case, okay? And the Blogan case says, in its concluding paragraph, in will contest, procedures laid out must be exhausted before there is recourse to a motion for summary judgment. So that's 2003. This was all going on in 2002, as I recall. So leaving aside whether there was a disputed issue of material fact. In this case, what would have been the advantage of going through a Rule 16 procedure to you? Because you were already, as I understand it, if you're already saying, look, I can meet the Rule 56 standard, which is what I hear you saying, correct?
Yes.
Why do we have to go through a Rule 16 procedure?
Well, there's two parts of Rule 16. One is the dismissal, but the second part is the immediate pretrial conference to narrow issues.
Right.
And that is an important element of that rule, which should be maintained in most circumstances. And might have been able to narrow down the issues a lot more quickly.
There was no problem. I mean, the issue here, as I think the motion judge found, the only question here was that that there was evidence of competence and maybe undue influence by the testator, correct?
That's correct.
So there was no...
So there's two issues. There's two issues. I don't know if you would eliminate either of the issues, but you may be able to narrow the focus of discovery. There are a number of things that can be done.
Yeah, but your people waived it by agreeing to go ahead with the summary judgment in the trial court. The reason I'm harping
by objecting on that basis.
Correct. The reason I'm harping on this is tricky stuff. This is very tricky stuff. And if we can resolve that issue on a waiver and go directly to the Rule 56 point, we can open it up for the probate judges themselves to reconcile what appears to be a glitch between Rule 16 and Rule 56, without us inserting ourselves in the middle and perhaps issuing an opinion that will create chaos down there. Because will contests are fairly common, are they not?
Especially in these, in fact, the facts in Brogan are very similar here. You have a sibling excluded, or two, I can't remember, and the excluded sibling coming in saying that the included sibling, the sibling beneficially used undue influence because my mother was incompetent or my father was...
You don't represent the two who were excluded.
Yes, he does.
No, actually, no. I don't.
They got dollar. Your clients
Right.
got specific dollar.
Correct. That's correct. But obviously, I don't know that anyone would disagree that there was a substantially disproportionate distribution of the assets, and which is part of the reason for the objection. But get back to the specifics on testamentary capacity. Of course, the burden of proof is on the person who is saying that the testator is competent. And in here, we have specific evidence of observations by an individual. I think that's sufficient alone to get beyond the summary judgment bar. Now let me go back to the medical records. There's been a nice characterization of these medical records saying, well, she was on a medication and it was all resolved and everything was hunky-dory. I don't think the medical records say that at all. I think this is kind of a nice invention. There certainly wasn't a reaction at one point to her antidepressant medication previous that had been, then they took her off antidepressant medications entirely, but she had been on an antidepressant medication for over a year. She was very depressed under the circumstances. She had just lost her lifelong partner. She was very ill. There were a number of reasons why she was very depressed. When you look at the whole list of the medical records, you can find that she was a person.
I think the medical records chronicle various difficulties that she's having. She's on the medication. Problems are reported with it. She's taken off the medication, and thereafter, the medical records, or at least for the relevant time period, are silent, i.e., they are not reporting the kinds of problems that they had noted before.
They're not reporting much of anything. There's one medical record for 1 month.
That might be because there's nothing to report.
Well, we don't. Well, maybe and maybe not, since there's no depositions. Who knows?
Mr. Class,
yes.
I mean, here, I'm just looking at the judge's decision, right? He's looking at the time the will is executed. He's got medical records from either the contemporaneous date or very close, saying she was bright, alertive, and conversive 10 days beforehand. Two witnesses, both of whom were employees and one of whom was a nurse practitioner, both witnesses declared she was of sound mind and under no undue influence. No evidence presented by the contestants to overcome the presumption that the testatrix was competent and sane at the time the will was executed. I mean, I think this is not a huge estate. This is not a huge estate, and I think one of the things that probate judges look at very carefully is I mean, if you want to open it up to depositions and to doctors and to so on, I mean, the entire estate will be eaten up before you get to it. Before you get to it. Which is not to say that you're not entitled to that. But I think what this judge is saying is to sort of generally talk about medical records when it's very clear what the claim here is. My mother was ill, and my brother used that opportunity to exert undue pressure on her.
Yes. Well, let me go. I've only got a few minutes to get me go to the undue influence, because I think there's a substantial evidence of that. You have a situation where...
Just before you do that, let me ask you one question. Did the judge here, in fact, make a decision sua sponte under Rule 16?
No, the appeals court said... I mean...
Did the probate judge, by striking the affidavits, make a decision under Rule 16?
That's a good question, because I think it was kind of unclear exactly what he was doing, because it seemed like he melded the two together.
He has to strike the objection in order to let the probate of the will proceed. On the undue influence, I know you want to talk about that. Let me ask you this. As I understand the attorney's affidavit, the problem here is that the biggest asset in the estate is the house. And the woman was very reluctant to have, what she didn't want to give that in equal shares because it was going to lead to the sale of the house. There's nothing irrational about that, is there? This is not one of these cases where there's evidence of undue influence because it's an irrational form of distribution. This is the family home. I want it to go to a member of the family. I don't want to put it in a situation where it will have to be sold. And it was going to have to be sold in order to create a, quote, equal distribution amongst these siblings. Well, she had a rational reason, in other words, for her unequal distribution.
Potentially. But the real issue is, was she fully aware of all of the options that were available to her?
Well,
the
attorney certainly says she explained those, that there were tax ramifications and there were this ramifications.
No, in terms of rather than selling the house immediately, that the house could, the brother could obtain a mortgage and distribute the value of the assets to the other siblings as part of a distribution in that way. I mean, there were a number of ways, and there were other considerations because there was the issue. One part of the discussion talked about the nursing home and the potential expenses, and there was a suggestion that maybe the son is going to receive nothing because the house is going to have to be sold for nursing home expenses.
Was the son living in the house at the time?
I don't believe there's anything in the record that says that one way or the other. So I suggest, I know my time is up, but there was a substantial amount of evidence. I've highlighted it all in my brief that establishes a case to go back before the probate court for further consideration and further discovery before this case is rashly ended on a motion for summary judgment.
Thank you.
Thank you.